Hello, my name is Osha. I like talking about American presidents, and I also draw attention to color of law violations, pivoting on subordination of perjury and fraud on the courts, uh, which specifically I'm talking about the trumped up charges filed against me in Montgomery County Circuit Court, Maryland, superintended by a corrupt judge, Judge James Bonifant, in order to obstruct justice. I'm going to do another video in which I relate the obstruction of justice part to the Watergate scandal of President Richard Nixon. I'm specifically referring to the what was called the Saturday Night Massacre, in which President Nixon, in order to prevent the special prosecutor Archibald Cox's investigation into the Watergate scandal, and in order to cover up, President Nixon asked Attorney General Richardson and Elliot Richardson to fire Archibald Cox, the special prosecutor who was asking for some tapes from President Nixon and continuing, aggressively pursuing the Watergate scandal, uh, and which would reveal the White House's involvement. And of course, the Attorney General resigned. He refused to fire Archibald Cox, and he resigned. And then he got another, a deputy acting Attorney General um, by the name of House to now fire him. He also refused, and he resigned. Eventually, the Solicitor General Bork, he went on to Robert Bork. He went on to fire Archibald Cox. Eventually, anyway, the fallout led to the intent of Congress to impeach President Nixon, and Richard Nixon subsequently resigned. So the ethics here is that President Nixon was trying to obstruct justice by getting someone to fire Archibald Cox while he was conducting his duties in order to cover up, cover up federal his misconduct or another official's misconduct. So that is illegal. Eventually, the termination was deemed illegal. So as of the day I was assaulted by Montgomery County Police, I was actually an auditor in the Department of the Navy, and had prior to that, I'd been a financial analyst as a John S. McCain Strategic Defense Fellow, and I was involved in some investigations. I had filed complaints regarding misconduct, including senior executives, and it turned out, that they were doing things behind, and this, the actions led to a swatting, right? They instigated a swatting, and I was in my home, and Montgomery County Police came and assaulted me. In any event, I'm not going to discuss the role of the federal government and Department of Defense officials right now in trying to obstruct justice. Right now, I'm going to continue with um, my motions and my defenses regarding the trumped up charges filed by uh, Montgomery County Circuit Court's Montgomery County's state attorney, John McCarthy, in order against me, in order to obstruct justice and to discredit me. So I did an earlier video called Motion to Dismiss, and I listed the charges already. And today I want to specifically look at a defense. Uh, the county, the state attorney has failed to specify, provide a bill of particulars specifying what what mode of assault they're charging me with, so I can provide an appropriate defense. Because you find that there's something called the Model Penal Code, right? While it's not a law, it's sort of like guidance. It's persuasive guidance that various states use, and in order to uh, they try and standardize uh, elements of criminal law. There are also statutes, right, regarding various forms of offenses and their corresponding penalties. So today I'm going to be looking at a specific case that deals with intent to frighten assault, because In my case, right, I've done videos in which I gave details about what happened, at my, apartment. I was alone at my home, although I was swatted. But of course, I've been wrongfully charged by the police officers who came and they swatted me, right? They falsely imprisoned me initially and they tased me, they shot at me. But ironically, to add insult to injury, the police officers, including a police officer, Jeffrey Ray, who shot me in the head, claimed that I assaulted him, right? So um, there's no battery, right? There's no battery because they were at a distance, right? I didn't touch any one of them, so there's no battery there. Um, and of course, I was backing them. I was backing them at the time. So the only in the absence of a bill of particulars specifying what type of assault, specifying the modalities, right? Um, I'm figuring, from my studies and from what my attorney has told me, uh, maybe what we're trying to defend is an intent to frighten assault, and it's called a specific intent crime, right? A specific intent crime. So there are elements to it, and that's what I'm going to try and talk about today. I'm gonna I'm going to try and discuss defenses and describe that type of assault. And specifically, I'm going to be looking at a case. There's a very interesting case. It's called the United States versus Acosta-Sierra, and it's a 2012 case. So, first of all, let me provide the elements of specific intent um, assault. So, so for specific intent as assault, there doesn't have to be a battery. A battery is an offensive touching or harmful offensive touching, right? So the specific intent would have to be like an intent to frighten. So that's why it's called intent to frighten assault. So the intention of the actor or the defendant was to cause fear of an imminent harmful contact, right? Or of imminent or impending offensive touching or contact, even though but it's separate from the actual contact. So the objective of the the definition of the intent to frighten assault as a specific intent crime is that it's it causes fear. It's intent specifically to cause fear in the victim, right, of an imminent harmful contact. So it's separate from the harmful contact or offensive contact. So the result is supposed to be fear as a specific as a specific intent crime. In this case, intent to frighten assault. And there are three elements to it that are generally required, right, to be met. That the state, the prosecutor, right, who's the plaintiff bringing the charge, that they generally supposed to meet, right? Those three elements have to be there. One, there's a threatening act, right? And I'll give an example of a threatening act. A threatening act can be charging with a knife. You have a knife. The defendant or the actor has a knife in their hand, or the or raised fist, right? Or raised fist, So threatening act is not merely words, right? Words don't are not sufficient, right? Making threatening words are not sufficient for the intent to frighten assault. So a threatening act, it could be a raised fist, it could be a brandishing a knife, right? So that can be the threatening act. That's one element. The second element is the uh, specific intent, right? The which is also uh, it can be considered the criminal intent or uh, the men, which is the mens rea element, right? Mens rea element. I've done videos in which I've talked about um, the elements that are required in order to convict for a crime, right? Generally in the US in common law, two elements at least required, and that's actus reus, which is typically the voluntary physical act, or the act. So if it's in terms of battery, then it's the hitting, right? Um, so there's still an actus reus, you know. So actus reus is normally, so in the case of intent to frighten, the actus reus would be the threatening act, like brandishing a knife, right? Even though they don't have to make the offensive contact. If it were a battery, right, a battery that's an offensive touching or harmful touching, it will be the contact, the actual contact. But for the intent to frighten, uh, specific intent assault, it would be just the threatening act. For instance, they're brandishing a knife, or they are holding a weapon, or they have a raised fist. So that would be the actus reus. On the other hand, there's mens rea. Mens rea is a mental state, or the guilty mind, right? The intent to commit a criminal act, right? Again, it's called guilty knowledge. It's mens rea, and it is a Latin term meaning a guilty mind to do something bad, something harmful, the intent. So that's the second element of the intent to frighten uh, assault, which is to have the specific intent to cause fear, right? They have a specific intent to cause fear, or apprehension of impending harm, right? So that's the second element. And then the third element that's required is generally required typically, right? The third element is the victim must have uh, a reasonable apprehension of fear, right? Of harm. They must experience a reasonable apprehension of fear, which is subjective, right? Under the circumstances, right? So that's the third element. And so I want us to look at this specific case. Um, Before I do that, let me also mention defenses. So there are defenses also to the specific intent assault. For instance, if it goes to trial, as it goes to trial, our defenses, or even as I'm filing a motion to dismiss, I'm going to raise, the defenses that look for a specific intent uh, crime, that is intent to frighten, assault. I have these defenses, and they're valid, they're clear, and so the state cannot prevail, right? They can't prevail. They can't prove to a jury beyond a reasonable doubt. And one of the defenses is mistake of fact. I did an earlier video stating, what a mistake of fact is. In my case, for instance, um, I was scheduled uh, to undergo a physical and psychological training with the military. And so when I was locked in, I didn't know the police. Somebody had gone to lie against me with the police. I had no idea. So that was when I was locked in, falsely imprisoned, and I come out and I see a troop of officers, and I'd intentionally screamed, because, of course, I was in a state of fright because I was falsely imprisoned. I didn't know what it was. It was supposed to be an exercise. That was what I thought it was. But there I was thinking, oh, I don't want to fail this exercise. They're giving me a test. Oh, well, it's a hoax. So that's a mistake of fact. I'm thinking, these aren't really cops with me. I'm thinking it's something else. And it can also be an accident, right? So it's accidental, right? Something, for instance, there's a car that's coming at you, and you're trying to avoid being harmed. And so you jump out of the way and you accidentally fall on someone, or you are about to fall on someone, and they're scared, and they get a heart attack because you're jumping out of the way to avoid a car that's coming at you. So that's an accident. So an accident is a defense. A mistake of fact is a defense. Uh, a joke, right? If you're joking, obviously, I thought it was a hoax, so I was joking as well. So I thought it was some kind of hoax. This is the era that people are normally punked. And so there was a video. If you watch the body cam, you see I'm actually calling out the name of the officer who had emailed me and scheduled the appointment for that same day that the police came at me, right? So they came to get me ostensibly due to a false 911 call and another false, perjured, and fraudulently obtained emergency evaluation petition by a man impersonating himself as my uncle when he's not, that I was not aware of. everything he said was a fabrication. So I was thinking I was being punked, that it was a hoax. It was part of uh, the uh, the scheduled physical and psychological test I was supposed to be having with the military on that day, which was scheduled on that day, and I have an email as evidence. So a mistake of fact, an accident, or a hoax. If you're just joking, then there's no, you don't have any criminal intent. You don't have intent to harm anybody. You don't have an intent to scare anybody. So they can't prevail. So those are things that negate the criminal intent aspect. Um, Another thing that can negate criminal intent is diminished capacity. And that's why I want us to look at this particular case. This was what the defendant, his name's Acosta-Sierra, this was what he was trying to argue, that, due to diminished capacity. Diminished capacity can be, well, you're intoxicated, or you can argue you're involuntarily intoxicated, right? That's also diminished capacity. Like in my case, I'd been drugged, and I'd also informed my friend that, okay, hey, it looks like I've been drugged. So that is there was bad faith. So in all of this, by the way, something that negates the whole thing, the whole charges, the whole case, is the bad faith of the police officers, or the government. If they did things to provoke the situation, right, it negates it. Self defense is also remember what? Sorry, before I say the self-defense thing. Remember, we looked at the case, the derivative, the origin of the fruit of the poisonous tree. I keep referring back to that case. It's very important. That's Silverthorne Lumber Company versus United States of 1920, which established the derivative or the fruit of the poisonous tree um, uh, principle, doctrine. And Oliver Wendell Holmes himself said, it is a lesser evil that a few criminals escape than that the government play an ignoble part. So the government can't do things to induce an innocent man to commit a crime. They can't illegally obtain evidence. They can't illegally instigate the defendant to commit a crime, and they can't go and gather evidence, because the state is going to need evidence in order to prove their case. So if the government did things like they came to my home, in my case, they came to my home without an arrest warrant, right? They violated the Fourth Amendment. Remember, let me recite the Fourth Amendment again. I'm memorizing it, so it's good for all of us to memorize it. Americans, it's good for us to know, especially in these times, it's good for us to know our rights. And the Fourth Amendment is a very big one. um, so the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, remember, I'd also talked about probable cause. I mentioned probable cause in here. And so let me again give the definition of probable cause, which I like from Brinegar, the case of Brinegar versus United States of 1949. So probable cause, the important elements, are six, and you see them in this statement that I make. This is the sentence. It has all the important elements of probable cause that we need. The facts and the circumstances within the officer's knowledge, with reasonably um, trustworthy information, right? Uh, Sufficient uh, to warrant a belief by a man of reasonable caution, right, that a crime is being committed. And so that's probable cause. Again, the facts and circumstances within the officer's knowledge, with reasonably trustworthy information sufficient to warrant a belief by a man of reasonable caution that a crime is being committed. I was not committing any crime. So I was just in my home. I was where I was supposed to be, right? And the police came and forcibly imprisoned me. And so they don't have a chance. So that's where there's prosecutorial misconduct, because the prosecutor, the state attorney, did not meet those standards. They didn't meet the standard of probable cause that a crime was being committed. They manufactured the crime, right? They thought of the crime. They fabricated things. They created false witnesses, right? That went to go and fabricate things. I've done videos concerning that. So let me focus on the intent to frighten element, and I'm going to quickly talk about the case so this video doesn't get too long. So um, so now we go into the case of Acosta, right? Acosta, that's Acosta-Sierra, that's United States versus Acosta-Sierra. So he had been convicted, but it was reversed by the Ninth Circuit Court of Appeals, 2012. So we see there are a lot of cases that normally go to the Ninth Circuit of Appeals, right, through the Ninth Circuit of Appeals. Remember, even the Korematsu cases, the cases we dealt with when I was discussing the wrongful Japanese internment cases during the Second World War. Those went through the Ninth Circuit as well. So the Ninth Circuit, gets a lot of cases that influence us, a very persuasive law. They tend to influence the U.S. Legal system. So so this guy, he throws. So the case was he had been convicted of assaulting a federal officer, right? So I wanted to deal with this case first because it's police officers that are falsely charging, claiming that I assaulted them, even though it's intent to frighten. And there's an intent to frighten element in this case as well, because it's intent to frighten because the Acosta did not actually hit the police officer. So the name of the police officer was Lopez. So Acosta was actually initially convicted at a bench trial. A bench trial means they didn't use a jury. It was judges, right, who made the decision. The defendant has a right to ask for a jury trial, or if he wants a bench trial. A jury, those are made of typically of 12 people, members of the community. They're a jury of your peers. Some people will, so you can waive that when the defendant is taking a plea, right, whether guilty or not guilty, then they can waive their right to a jury. The right to a jury is protected in the Sixth Amendment. So this guy had a bench trial, right? He decided he wanted to have a bench trial, and that's when the judge, decides himself. So you can see this case now. He appealed, and it went up to the appellate court, and they reversed his conviction. So you see, judges make mistakes as well, and especially with this intent to frighten element. So you see from this case that intent to frighten is a bit nebulous, especially when it's dealing with police officers. So it's nebulous, it's vague, it's not clear. Especially when you're dealing with mens rea, for instance, when you're dealing with uh, intent, criminal intent, because you don't know what's in the mind of the person. But the way the courts normally, or the courts or ask the jury to interpret intent would be from the conduct of the actor, the defendant. The circumstances, what uh, actions did they take that one can reasonably infer that they had the intent to actually commit the crime, right? So, for instance, if somebody has a knife and they're charging at someone, well, the judge will say that they did demonstrate intent, a mental state to commit the crime. That they met that requirement. Um, but in this particular case, it wasn't the intent element was there, right? That the uh, Acosta, the defendant who had been convicted, was challenging the uh, the instructions to the judge, or the standard that the judges used, in which they dismissed the criminal intent requirement, saying that was not necessary, right? And so it was one of the reasons why the appellate court, the Court of Appeals, actually reversed the conviction, but it wasn't the main reason. The main reason was because of uh, the subjective reasonable apprehension of the victim, right? That the victim feared imminent danger, right? And that it was subjective. So I'm going to just, you know, narrate what happened in the case. So the police officer was a federal officer. His name was Lopez, and he was walking, and Acosta had thrown a stone at him, but he was backing Acosta. He didn't see Acosta. He only knew Acosta had thrown a stone at him when the stone landed, away from him, and he looked back and he saw Acosta, but he didn't see him holding any weapons or more stones or anything like that. Now, in during the case and the statement of Acosta, he claims that after he realized that Acosta had already thrown a stone, and he looked back and he saw Acosta, even though Acosta was not holding, new weapons or brandishing more stones, he said he feared the situation, realizing he could have been hit, right? So that was the fear he had was after the events, right? So at the district court, the judges had concluded that, well, because of the proximity of his mental state of the fear he experienced to the act, right, of the stone throwing, um, that it was sufficient, right, to convict, to find that he did meet that element of fear, that's the officer, the victim, that he satisfied that element of reasonable apprehension of fear, right, which is subjective the to the victim, right? Subjective. Now, when they say reasonable, right, it's reasonable in that somebody else in the officer's shoes, right, would experience the same fear, right? Would feel that fear of impending harm as well, of offensive physical contact, that they'd experience that fear as well. So not just the particular officer. In fact, as I was reading the case, it was very interesting that the judges were comparing, uh, in order to establish what reasonable apprehension of fear means, they likened it, they drew a parallel with maybe somebody who's a champion pugilist, a champion boxer. Pugilist was the term they used, uh, who was in danger of an intoxicated, scrawny man, right? And they're saying, that even though that the champion boxer typically, he's stronger, he shouldn't feel fright, but it doesn't mean that he can't feel under certain circumstances. The intoxicated person doesn't mean that he can't put him in a state of, fearing uh, of an offensive, imminent contact, because that's what really the fear that the element is describing, that an offensive contact is going to happen, right? So for instance, even a police officer who has a a gun, you should think about it. A police officer who has a gun, and there's someone he wants to arrest, a civilian he wants to arrest who doesn't have a gun, who just has his fists. Can the police officer who's brandishing a gun at the civilian, can they be said to experience reasonable apprehension of, a reasonable apprehension of imminent offensive contact, right? So let me not answer that, but these are things that one has to consider. In my case, what was it? I was alone. I've already, the issue that there was a mistake of fact, and uh, and a hoax, a swatting, that negates the whole intent, right? But consider another situation, somebody else who has just his fist and there are 30 cops pointing guns at him, and all he has is his fist or a knife. Um, would it be reasonable for the police officer to fear that that individual will cause uh, will cause will cause can create an imminent uh, apprehension of imminent uh, bodily harm? Would it be reasonable for the police officer or any of the police officers brandishing guns, and there's just an individual with his fists? Is it reasonable for them to, the fact that their guns can deter him, right? Can deter an attack. Uh, can that element of reasonable, uh, subjective fear of imminent or impending bodily contact or bodily harm, can it exist in any one of the officers? It's very debatable. Some courts think yes, that the what the officers can do, right, doesn't negate the actions that the actor, right, the defendant or the actor who has a specific intent to create fear of contact. It doesn't stop them because the officers can choose not to act, right? It's just the ability. So what's important as the element is in the intent to frighten as a specific intent as assault is that the actor, the defendant, has the present ability to carry out that threatening act. That they're going to hit somebody, or if they're going to stab someone, that they have that present ability to carry out that act, right? So that is what many courts lean to, right? That they do have the present ability, that the fact that the officer, the victim, has the ability to negate or deter them because they have superior firepower, superior weapons. In this case, the police officers have guns and they're more. The fact that they're able to shoot him before he actually touches any one of them does not negate, the fact that the actor or the defendant or the offender has the present ability to actually uh, cause that fear and of touching, creating an offensive touching or contact with uh, any one of the officers, or it has to be a specific officer, right? It can't be any random one, So because that officer, the officers can choose not to act, right? So what they can do to deter is not typically dispositive. It's not, you know, it doesn't weigh into the present ability of the offender or the actor, So in his ability uh, to cause fear of an offensive contact. Again, it's fear in terms of specific intent to frighten, assault. It's fear that's the result, right? Now, um, so back to the Acosta case. So the the rock never hits the officer Lopez, and he wasn't aware, right? He didn't have any present fear, right? Subjective present fear when the act occurred, when Lopez acted or when he was about to act. Remember, the apprehension that the victim has to feel is an apprehension of an impending harm, that the harm is going to happen, it's imminent, it's going to happen in the near future, right? So um, the the district court initially ruled in favor uh, of the police officer of the officer Lopez, saying, well, the fact even though the fear that Lopez felt was after the act, and he didn't experience that fear before or as he was about to throw the rock, because he was backing him, he didn't see him. They felt that because of the proximity, that even though it happened after, that he feared a little bit while after, that the fear element was still present, right? And another thing was regarding criminal intent. They felt that so long as the act was done, there was a conflation. When you're reading the arguments of the court the appellate court, they're saying there was a conflation with attempted battery, right? Um, because and so judges, uh, the judges did not include, they didn't consider criminal intent as an element, right? Um, Interestingly, something that the defendant, Acosta-Sierra, was also trying to argue was that he was not allowed to use the defense of his mental state, right? So a defense that can be used is, as I said, diminished capacity. So, for instance, somebody who has a mental disorder, he can use that as a defense against specific intent to frighten assault, because it will diminish the ability. It's supposed to not totally negate. It doesn't totally negate the mens rea requirement regarding this specific uh, intent to frighten assault. But the fact that in uh, Acosta-Sierra's case, the defendant, he suffered from schizophrenia, right? The fact that he suffered from schizophrenia, he tried to say, well, that the court should have admitted that into evidence, but that was never admitted into evidence. But the appellate court didn't think, it was necessary, because that he was the aggressor and some other things. So that wasn't critical. That wasn't crucial. But the important thing is the appellate court eventually reversed the conviction. And the most important reason why they reversed the conviction was that it said that the requirement for an apprehension of fear by the victim, that the victim fears imminent or impending bodily harm, or a contact or battery or whatever, that has to be before or at the time, at the time of the threatening act, right? At the time that the actor is committing the threatening act, not after it, right? So that if that, for instance, the police officer, the officer Lopez, should have, his fear should have been at the time the Acosta-Sierra, the defendant, was throwing the rock at him. So he should have seen him, and he would have satisfied that element of fear if he had seen him and then he feared at that moment, but not after it, not after the act had already occurred, right? You can't. So the fear requirement should be before or at the time the threatening act is occurring, not after it, right? Um, and so there was also a conflation in the lower court, in the district court, with attempted battery, right? That misses, for instance, they were making comparisons. Think, for instance, somebody who is walking and somebody fires a gun at them, but they miss. It doesn't hit them, right? And they see that person is still convicted of attempted battery, right? So there's that uh, there's the need to distinguish intent to frighten and attempted battery. Intent to frighten, the result is there's a specific intent to cause fear in the victim, right? Of that imminent danger, imminent offensive contact, even though that contact it's not consummated, right? So, um, if somebody so the present knowledge, the knowledge of the victim must be aware. They have to see the action for it to meet the intent to frighten uh, requirement, right? In order to satisfy the intent to frighten form of assault. So the victim has to see, they have to be aware, they have to have that knowledge that the offender, the actor, is conducting that threatening act, right? So if somebody's asleep and somebody uh you know shoots at them but they're asleep, then they don't know, and it misses or whatever, they don't satisfy that intent to frighten assault, right? So they have to be aware, they have to see it, and that fear has to be before or exactly at that time, right? It can't be after the threatening act. And so that's what's that's what's significant in the intent to frighten form of assault. Let me stop here. It's already 40 minutes. If I need to, just emphasize more about the intent to frighten form of assault, I'll do that. My name is Osha, and I'll keep you posted. Thank you.